Good morning. I'm Andrew Pollis. I'm an assistant professor at Case Western Reserve University School of Law. Welcome to this next segment in the Case Downtown lecture series. We're delighted to have you here this morning. Fill your coffee cups because this is about one of the, if you're not me or geeky people like me, one of the hardest kinds of lectures to stay awake through. We try to keep it a little interesting. There's some PowerPoint slides. We're going to be talking today about final appealable orders. I've been told to ask you to ask your questions, but not until the end. We are being simulcast on the internet, so at about 20 after 9, we'll have a Q&A session, and we will have people with microphones, so be sure to wait till somebody comes to you with a microphone so that the folks watching at home, whoever you are, God bless you, will be able to hear. I hope that you will share my enthusiasm for final appealable orders by the time our hour together this morning is concluded. And let's talk, we're going to talk a little bit about the federal final appealable order rubric, and then we're going to turn to the more complex area of Ohio final appealable orders. But the background of all this, the policies that underlie final appealable orders are twofold. Two balancing tests, if you will, that are always underlying the various kinds of statutes and rules that courts, legislators use in trying to figure out when you can take an appeal from something adverse that happens to you in the trial court. And the first of these is, when is the need for appellate review so compelling that it is worth interrupting trial court proceedings to be able to go up to the Court of Appeals and say, something bad has happened to me, we need to fix it, and we need to fix it now. Because, of course, when that happens, whatever's going on in the trial court is going to come to a screeching halt, potentially, and stop the flow of the litigation at that level. The second consideration is just a purely practical cost one. The more often we allow the litigants to invoke the jurisdiction of the Court of Appeals, the more expensive it becomes, the more judges we need, the more courts we need, the more infrastructure we need. So these two balancing tests are constantly at play when courts and legislators determine when it's appropriate to say, yes, you may go up now and have this particular kind of order reviewed. We're going to start with a brief overview of some of the various appellate jurisdictional issues at play in the federal court system. I love this quote. This is from 1890, when the circuit courts of appeals were first established by Congress. Contrary to what many of us might think, Article 3, which defines the judiciary of the United States courts, does not actually require there to be appellate courts. And so in 1890, when Congress decided to create the appellate courts, the congressional record reflects that it was the kingly power, and forgive the sexist terminology, but there weren't many, if any, female district court judges at the time, but the kingly power of district court judges was thought to be contrary to the principles of our democracy, and we needed some kind of more regular review than simply taking something up to the Supreme Court, which at the time was the only appellate jurisdiction that existed. So in federal court, the starting place for jurisdiction is the final judgment rule. Many of you may have heard that phrase. Almost all of us are familiar with the concept, which is that you can take something up on appeal always if the order in question ends the litigation on the merits and leaves nothing for the court to do but execute the judgment. When you've reached that place, and we all kind of think we know it when we see it, when the case in the district court is done, at that point, by all measures, you can go upstairs and ask the Court of Appeals to fix whatever went wrong. The benefits of the final judgment rule is that it's efficient. It's a clear rule. We know when it happens. We know when we get there, and it also doesn't interrupt the trial court because the case at that point is concluded. It conserves appellate resources because it is a one time that you can go up, and it doesn't invoke that jurisdiction multiple times. And it promotes certainty because I said we all know it when we see it. But maybe that's a little too facile, because the Supreme Court has repeatedly recognized that the final judgment rule, despite what appears to be a pretty clear-cut rule, There's no satisfactory definition of this term, so I'm not so sure that it really does promote certainty, and that's even if you're just focusing on the final judgment rule itself. But the problem is that our appellate jurisdiction is not confined to the final judgment rule itself, and in fact, there are multiple exceptions to the final judgment rule in federal court, and you see them here divided into two categories. One of them is mandatory, and one is discretionary, and I'll just briefly walk through them. We don't have time to talk about them all in detail. By mandatory, what that means is that the appellate court has no choice. It must accept jurisdiction of an order that falls on the left side of this column. The first of these is the collateral order rule, and I hesitate to put this under a title of a slide that says interlocutory appellate jurisdiction, because if you read characterizations of the final judgment rule, it's often described as an interpretation of the final judgment rule rather than an exception to it. So it isn't actually interlocutory. But the collateral order rule is essentially a rule that says when something happens that is collateral to the merits of the case and is so important that we need to have an immediate appellate review, we allow that review, we consider that to be a final order, even though technically the case isn't over. A perfect illustration of the collateral order rule is a finding of non-immunity. If you sue a government official and that government official claims to be immune from suit, and the trial court says, no, you are not immune from suit, then suit goes forward, that is a collateral order that can be appealed right away, the thinking being that if you don't allow the government official to appeal right away, you are depriving that government official of the benefit of the immunity because they shouldn't have to be in the trial court in litigation in the first place. And if you waited until the end of the case in order to allow the appeal to go forward, you would be depriving them of something that is important even though it's collateral to the merits. Preliminary injunctions, admiralty issues, and receivership issues are defined by statute in 28 U.S.C. 1292A. Those are considered immediately appealable even though they are interlocutory orders. And orders denying motions to enforce arbitration clauses under 9 U.S.C. Section 16, those are also immediately appealable interlocutory orders. On the other side of the chart are those that are characterized as discretionary. These are the kinds of orders that can go up on appeal but do not automatically go up on appeal. It depends on whether the trial court and or the appellate court are willing to let it happen. So, for example, 1292B, 28 U.S.C. 1292B, is a statutory provision that gives the trial court the discretionary power to certify for immediate appellate review certain kinds of rulings on dispositive legal issues that would advance the termination of the case quickly if we allowed the Court of Appeals to weigh in on a legal issue. So, for example, if there's some novel issue of law that the trial court has had to grapple with, and it's not quite sure whether it got it right, the trial court can say, I certify this question under 1292B, and the Court of Appeals then has the discretion whether or not to take the case at that point. So it's discretionary on both levels. Partial final judgment under Rule 54B. We'll talk a lot more about 54B when we get to the Ohio rule, but essentially Rule 54B is a rule that gives the trial court discretion to take something that has been concluded in the trial court on one party or one claim that has been decided in a multi-party or multi-claim action and take that piece that's been decided and sever it off from the rest of the case by entering a final judgment. The trial court does not have to do this. It's discretionary. If the trial court does do it, then it becomes mandatory for the Court of Appeals to take the case. So this one is discretionary on the part of the trial court and then becomes mandatory at the appellate level. And then the mandamus and class certification decisions and appeals of issues involving remand of cases under the Class Action Fairness Act are also in the category of orders that the trial court and or the appellate court have discretion to decide whether to hear right away. So this same chart that we looked at that talks about the distinction between mandatory and discretionary, you can also, just for your own understanding of where these rules come from, if you color-code it as I have here, you can see that in the federal appellate system, the sources of appellate jurisdiction come from multiple different sources. The sources come from multiple sources. The first, the red one there, that's judge-made case law. The collateral order doctrine is a creature of the common law of our federal appellate jurisprudence. The green writing, those are statutes, Congress enacted statutes that provide for those categories of appellate jurisdiction, and the blue ones are court rules that the Supreme Court, through the Rules Enabling Act and the commissions on the amendments to the civil and appellate rules, actually in this case both civil rules, have promulgated rules that create these avenues for appellate jurisdiction. So it's kind of all over the map where they come from, and as you can tell, all over the map in terms of whether it's final or interlocutory, mandatory or discretionary. But underlying all of this is the notion that we want the courts of appeals to be able to review district court orders that have this serious, perhaps irreparable consequence. That's the kind of concept that underlies all of this, that if it's serious, if it's important, and if it's irreparable, meaning if we wait until the end of the case, we cannot adequately give the kind of relief that we want the appellate courts to be able to give, those are the kinds of categories of cases that we want the courts of appeals to be able to hear at the moment when that order arises. And so if you go back to our chart, you can divide the world again between mandatory and discretionary. And in the mandatory category, you see that Congress or the Supreme Court has decided every single one of these orders has that serious, perhaps irreparable consequence component to it. Every one of them is one that we want people to be able to appeal immediately because that's how serious they are. That's how irreparable it would be if that didn't happen categorically. On the other side of the chart, these are categories in which sometimes it's serious, sometimes it's irreparable, but not always. And rather than try to kind of lay a rule down that we're going to be able to apply consistently across the board, we tell our courts, you guys figure it out. If you think this particular order fits that serious, perhaps irreparable consequence test, or whatever incarnation of that the language of the particular statute or rule uses, then we'll let you do it. But we're not going to say you have to do it always. So that's kind of in a nutshell how the federal appellate jurisdiction categories break down. Now we're going to turn to Ohio. And as you see from the slide here, when you blow Ohio up out of a big federal map, it's fuzzy. And that's kind of a metaphor for what we're about to experience because Ohio appellate jurisdiction is a mess. Read more about it in your written materials. My little shot for promoting the Ohio Appellate Practice book that I co-author with Judge Mark Painter is that what you have in your materials is last year's edition. If you go on to westlaw.com at the website that's listed on the first page, you can buy for hundreds of dollars, of which I make about a nickel, this year's edition, and it comes out every year. Enough of my plug. All right, so where do we start? Well, the starting place in Ohio for appellate jurisdiction is the Ohio Constitution. And Article 4, Section 3B2 basically says that Ohio courts of appeals have appellate jurisdiction over judgments or final orders as may be provided by law. This is just kind of a nice, generic, we're not really going to tell you yet, we'll let the law figure that out. By law, they generally mean the General Assembly. So then you have to look to the General Assembly's construction of the Constitution, and according to the Ohio General Assembly, every final order, judgment, or decree of a court may be appealed. What do those terms mean? What is a final order? That's a really messy one. We're going to come back to that. Let's do the simple ones first. Because if you focus too hard on final orders, you feel like Macaulay Culkin in the Home Alone movies. So, what is a judgment? Well, if you are an original intentist, you'll go back to the language of the Constitution, which at that time was thought to be a final determination of the rights of the parties to the action. That sounds like language awfully similar to the final judgment rule that we saw from the federal courts, and in fact it is. And this is basically what we understand a judgment to be even today. If you look at Rule 54A of the civil rules, in the civil context at least, it gets a little bit murkier because it defines a judgment as a decree and any order from which an appeal lies as provided in 250502 of the revised code. Well, that's kind of circular because we thought we just learned from the revised code that a judgment was one of the things you can appeal. So now you're telling us to go back to a different statute and try to figure out what how judgment is used in the statute to figure out how it's used in the rule to go back to the other statute. So there's a lot of circularity here. And then it comes back to this word decree, which of course is also in 250503 as one of the three categories that the General Assembly has said may be appealed. And what do you see when you go and look at what a decree is? You essentially see in the staff note to Rule 54A from 1970 that a decree is a judgment, except in the context of an equity case. So judgment and decree are basically the same thing. One, a judgment you get in a case for money damages. The other, a decree you get in a case for equitable relief, like a declaratory judgment or something like that. So the circularity is really kind of back and forth here. But at the end of the day, I don't think we get too much difficulty from any of this because both these words, judgment and decree, seem to fit into that category that we've seen now repeatedly in the federal and in Ohio law when the case is all done. And we know it's done and we know it when we see it. So that then requires us to go back and look at final order. This is the real difficult one. And instead of feeling like Macaulay Culkin, let's ask the question, what is a final order? And let's try and come up with some answers. All right. Well, coming up with an answer in Ohio is a little bit difficult. And the reason it's difficult is that if you flip through the Ohio Revised Code, you will find statute after statute after statute after statute that uses the phrase final order. This is a final order. This is a final order. This is a final order. And they're scattered throughout the Revised Code in different places. There is not one statute, one single statute that collects them all in one place for us to use easily. I mean, that's why we're in business as lawyers. If it were that easy, they wouldn't need us. So you got to know where to look, but at least we have one principal statute, that's 250502, that is the statute where you can look first. And all of the rest of them, although they're important and you need to know about them, they are not the place to go first. The place to go first is 250502, and so that's where we're going to focus our discussion. 250502, Section B, says that an order is a final order that may be reviewed, affirmed, modified, or reversed when it's one of the following, and then it lists 7 different kinds of orders. Now let's just keep in mind here why we care about 250502, because we learned from 250503 that every final order, judgment, and decree may be appealed. So here we're getting an example, not just an example, a list of 7 different kinds of final orders. If it's one of these, you can appeal it. So we're going to walk through some of these. And this is the most important one of them. 250502B1, an order that affects a substantial right in an action that in effect determines the action and prevents a judgment. Okay. Lots of words in that we need to make sure we understand, and they become hugely important in figuring out Ohio appellate jurisdiction. The first of them is substantial right. What is a substantial right? Well, the statute, at least in this instance, codifies that for us. A substantial right means basically any right that any law, rule, statute gives you the right to enforce. This is kind of circular too, and it's kind of, you know it when you see it too, but it isn't particularly complicated. If you have some legal hook for some kind of right that you think you have, then under the statutory definition, it is probably a substantial right. That part is easy. But the statute also requires us to demonstrate before we can appeal that the order that we're talking about affects a substantial right. That's an important verb. It has to affect the substantial right, and the Supreme Court tells us that an order affects a substantial right if it's one that, if it doesn't have an immediate appeal, it would foreclose the right to relief in the future. What does that sound like from the federal system that we talked about a few minutes ago? That serious, perhaps irreparable consequence. Same concept. It has to be something where we need it now, because if you do it later, it won't be good enough. What might be an example of that? Well, if you are going to require somebody to do something immediately, such as if you're enforcing a non-compete agreement, for example, and you want the employee against whom you're enforcing it to stop working for the competitor, well, if you make that employee stop working for the competitor and you don't give that employee an immediate right to appeal from that decision, that person loses a job, loses livelihood. That would be something that would affect a substantial right. So a preliminary injunction would be a good example of that. Anything where if you don't get someone to look at it now, something bad will happen and we can't correct it later. If you cannot unring the bell, and that's a good way of remembering the seminal Supreme Court case in Ohio that essentially explained what this is about. So if you can't unring the bell, if you get review later, you have to do it now or it will be too late. That would be something that affects a substantial right. But that's not all. 250502B1 also has this phrase at the end that says determines the action and prevents a judgment. Well, what does that mean? In 1989, the Supreme Court tells us that for an order to determine the action and prevent a judgment for the party appealing, it must dispose of the whole merits of the cause or some separate and distinct branch thereof and leave nothing for the determination of the court. Well, that sounds familiar. It must dispose of the whole merits of the cause. Sounds an awful lot like the slide we looked at before from 1922, a final determination of the rights of the parties to the action. So here we go again in this circular circle. That's the easy part. This is where things get tricky. Some separate and distinct branch thereof. And that, ladies and gentlemen, is where Rule 54B comes in. Remember I told you when we looked at Rule 54B in the federal system, we would be coming back to it in Ohio. Well, here we are. What is Rule 54B? Rule 54B is gobbledygook. Anybody who tells you how to make a PowerPoint presentation would tell you never, ever to put this many words on a slide. But if you want to quote Rule 54B, you have no choice because that's how long the rule is. Judge Painter, who co-authors the book with me, will often tell you where a piece of text fits on the something Kincaid scale of readability. I forget what it's called. But he runs Rule 54B through the whatever scale of readability, and it comes out as being something that no high school graduate could ever possibly make heads or tails of. And so I'm not even sure lawyers can. But in any event, we're going to break it down just a little bit. Okay. Rule 54B, if you remember what we talked about in the federal context, I told you and I went over it very fast, but essentially if you've got a case that has multiple claims or multiple parties or both, Rule 54B is the rule that gives the trial court the power to take some of those claims and resolve them with finality, even if others of them remain pending in the trial court. Okay? So if I sue you and I sue you, and the trial court enters summary judgment in your favor against me, my claim against you is not going to go forward, but my claim against you can still go forward to trial. We have two parties, a multi-party claim, okay, multi-party action, and one of those has been resolved. Is that a final order on its own? No. But the trial court has the discretion to use Rule 54B and make that particular order a final order because it completely resolved that claim, even while this claim remains pending for trial in the trial court. Okay? So, and the language of the rule says that the court may enter final judgment as to one or more, but fewer than all of the claims or parties, only upon an express determination that there is no just reason for delay. No just reason for delay is often referred to as the magic Rule 54B language that must be invoked. The trial court order must literally say, summary judgment is granted in favor of, I'm sorry, what is your name? Kira. Summary judgment is granted in favor of Kira on all of her claims against Pollis. There is no just reason for delay. That becomes a final order. Okay. So when we talk about some separate and distinct branch thereof in 250502B1, That's what Rule 54B gives the trial court the power to do, to create that separate and distinct branch and break it off, okay? Now, you all have on your table Kit Kat chocolate bars, and they're there for a reason. Everybody get one out. Go to open your candy. You don't have to eat it. I know it's early in the morning, but we're doing this for a reason. Open it up. And anybody who's willing to sing the Kit Kat jingle gets extra bonus points. What's the Kit Kat jingle? Give me a break. Kira, okay, give it to us. All right, break me off a piece of that Kit Kat bar. Can you toss me one of those up here, please? I forgot to. Thank you. All right, now, why do you have Kit Kat bars? You have Kit Kat bars to make sure that you actually understand the way Rule 54B works. Because a lot of judges and lawyers mistakenly believe that when you put that magic language, no just reason for delay, on any order at all, it creates a final order that you can take immediately upstairs to the Court of Appeals. Is that accurate? No! What did I say you had to have? Yes, you have to have multiple claims or parties, and the order that you're certifying has to completely resolve at least one of them. It doesn't work for miscellaneous interlocutory orders like a discovery order or a trial-related procedural order. And this is why you have Kit Kat bars. When you break a Kit Kat bar, where do you break it? Yes, where it's scored, like that. Nice and clean. You separate one claim from another claim or one party from another party, and you break it off. It's almost as if you're dividing the lawsuit into two, like a twin embryo breaks off, okay? And this one gets to go to the Court of Appeals, and Kira is going to realize how mistaken the trial court was for granting her motion, while this one against Maureen goes on to the trial court, goes on to trial nice and happy, and we've got two different cases now. What you cannot do is break it this way. What happens when you break a Kit Kat bar the wrong way? You get crumbs! And the Court of Appeals does not want crumbs. This is a claim. You can't break a claim in pieces. You can break a claim away from another claim, but you cannot break the claim itself into multiple pieces. So, we have covered 250502B1. If it determines the action and prevents a judgment, it means it's all done, or there is an appropriate score-broken, claim-separating order from the trial court under Rule 54B. And Rule 54B is the catalyst for making that happen in a multi-claim or multi-party action that has not gone all the way to final judgment. Now, this is where I'm going to go on my soapbox, okay? We have a problem in Ohio because your Supreme Court justices don't understand the way I think they should, and I'm a professor, I get to say, how Rule 54B actually interplays with the statute. And here's why. In 1993, and this isn't the first and only time they've said it, in a case called Wizentainer, the Supreme Court essentially trying to explain Rule 54B. They were trying to explain to you the same concept I explained when I broke the Kit Kat bar the wrong way. You can't use 54B for everything. It doesn't transform a non-final order into a final appealable order. What it does do, they said, was transform a final order into a final appealable order. They have created this fiction that there exists a difference between a final order and a final appealable order. However, where, I beg you to tell me where, in the Ohio Constitution or in the Ohio Revised Code, there is any such distinction. There is not. The Constitution speaks of judgments or final orders. The statute says every final order may be appealed, not just the ones that are appealable. Think how great that would be if we not only had to figure out what final order meant, but then we had to figure out when a final order was appealable. Nonsense. So, this language from Wissentainer does nothing except throw the Ohio law of this already confusing issue into further disarray. And I ask you to petition the Ohio Supreme Court to fix this, and here's how I think it ought to be fixed. The phrase, no just reason for delay, transforms a non-final order into a final order if the order, and then quotes the language of 54B, if it adjudicates fewer than all claims of right to liabilities. In other words, if you have to say in other words, by the way, it wasn't clear the first time. In other words, if the order would be final, but for the pendency and the other claims in the case, then Rule 54B can render it final. But any final order may be appealed. Okay, now we now return to our regularly scheduled programming. Enough of my soapbox. All right. It isn't, though, as simple as I have made it sound. Not that I've made it sound all that simple. But Rule 54B in Ohio creates this added difficulty because you have to figure out what a claim is. If you are going to break the two pieces of the Kit Kat bar at the score, you have to be able to figure out where the score is, okay? And in 1989, the Supreme Court refused to allow 54B to be used in a situation in which there were multiple claims against a single party and the trial court had resolved two of them but had not resolved the other two. And the Supreme Court said this is not a 54B-able case. That begs the question of what a claim is. What is a claim? Go back to first-year civil procedure. What's a claim? I sue Kira both for negligence, for striking my vehicle with hers. I sue Kira for the intentional tort, also, of striking my vehicle with hers. She either deliberately went through that red light and hit me on purpose, or she was texting while she was driving and negligently didn't see that the light was red. Okay? And I bring both of those in my complaint. How many claims have I brought against Kira? I see two over here. Anybody disagree with that?
I think 4.
You think 4? Where are you getting the other 2?
What you said,
You're
allowed multiple claims because you have people conflicted claims in your complaint.
You guys have been poisoned by the Ohio Supreme Court and the confusing nature of, and I'm about to extract the poison from you, because I saw one over here. One claim. Why? What did we learn in first-year civil procedure? A claim is what? A transaction or occurrence, a set of operative facts, a common nucleus of operative facts, right? There is only one claim here. I have pitched that single claim with a couple of different legal theories against Kira, but it's the same car accident, one car accident. How I can recover against her for that single car accident, that's something for the courts and the juries to figure out, but it's only one thing, okay? So technically, the Supreme Court probably got it right. I don't know. They don't say clearly what the claims in Chef Italiano involved. But if it was anything like my lawsuit against Kira over here, they got it right. Because if Kira moves for summary judgment on the intentional tort claim, and she says, this is ridiculous. I was injured in the accident. My car was damaged in the accident. I've never even met this Pollis guy. I had no intention of causing him harm, and there's no evidence that I did. Dismiss that intentional tort theory, and the trial court agrees. Partial summary judgment granted for Kira. Trial on the negligence claim to go forward. Okay? The trial court hasn't resolved my claim against Kira. The trial court has simply narrowed the legal theory that I may pursue in my claim against Kira. One claim, all right? However, in 1992, the Ohio Supreme Court saw fit to amend Rule 54B to overturn its own decision in Chef Italiano. And the staff note to Rule 54B from 1992 now says, the rule is amended expressly to state that it does apply to multiple claims that arise out of the same or separate transactions. Okay? Now, separate transactions. I sue Kira for the car accident. I also sue her for the $500 she didn't pay me 2 years ago. Okay? That's two claims. One of those gets resolved. You can break that. That's a Kit-Katable separation. That works. But the car accident two theories, 54B is trying now to say, yes, those are two claims too. The rule is amended to state that it arises of multiple claims that arise out of the same transaction. There's no such thing as multiple claims that arise out of the same transaction. That is nonsense language. It cannot be. That sentence just doesn't make sense. But that's what the rule now says. Okay? So, this is the language of Rule 54B. I'm now highlighting a different piece of it for you. It now says that it applies whether the claims in question arise out of the same or separate transactions. That language, added in 1992 in response to the Chef Italiano case, does not exist in the federal version of the rule, and for good reason, because the federal rule makers understand it's just nonsense. All right. How do you apply Rule 54B? There is a two-part test. The first part of the test asks whether the disposed of claims are factually separate and independent for the remaining claims. An example would be claims that are based on different transactions or occurrences, such as one claim for slander and another for negligence because of an automobile accident. Thank you. This is a test that fits with what we understand 54B is supposed to be about, similar to my two claims against Kira. If you meet this test, okay, clearly that's appropriate for 54B under the federal or Ohio version of the rule. Second, if the claims are not factually separate and independent, do the legal theories presented in the disposed of claims require proof of substantially different facts and or provide for different relief from the remaining claims? Okay? This is where it gets really, really murky. The trial court in Ohio is authorized to put 54B language on an order that resolves something that is not factually separate and independent from a pending claim that's not done. That's the kind of murky scoreline in the Kit Kat bar. But it has to at least determine when it does that when you go to trial, the facts that you prove at trial on the claim that is not resolved are substantially different and give you a different relief from the piece of it, the intentional tort piece in the Kira litigation that is resolved. In my view, this is essentially the Ohio courts desperately trying to undo that 1992 amendment to 54B. Because if you think about how this would work in practice, you would never be able to use 54B the way the rule says, where you can actually apply it even to the same transaction. My case with Kira would never be appropriate for 54B under the second prong of this test, because it's always going to be substantially the same facts if it's the same claim. One more little important thing about 54B. In the absence of a determination, so we don't have, in this hypothetical, there is no 54B language. However many claims there are, however many parties there are, the trial court has not used that magic no just reason for delay phrase. The rule specifically says that the order then, if it is not yet final under 54B, is subject to revision at any time. Okay? What does that mean? Well, I've got my case against Kira and I've got my case against Maureen. Kira moves for summary judgment and wins, but the trial court does not put the 54B language on the order. I go to trial against Maureen. I call Kira as a witness at trial. And in a Perry Mason-like moment, she admits that she went through the red light and that all of the summary judgment affidavit evidence that she put in was perjured. Sorry, Kira. Can the trial court undo the summary judgment at that point? Absolutely it can. If it isn't final under 54B, it may be revised at any time. By contrast, if the trial court had rendered it final under 54B, the trial court would lose jurisdiction to do anything more with that piece of the case in the absence of something like a motion to vacate or a motion for relief from judgment. But with no 54B language, Kira thinks she's out. She thinks it's over. She thinks she's free and clear and it's done. But the trial court can change its mind at any time. This is a really important piece of procedural rule that you need to know for your clients in a multi-party, multi-claim action, because you may think you succeeded in knocking out, for example, the plaintiff's claim against your clients. But if there are other parties still in the lawsuit and there is no 54B language, 2 years later, while the case is still pending, the trial court has the right to change its mind. Doesn't have to give you any kind of notice, can just say, whoops, I got it wrong. The summary judgment order is vacated. Come back to trial next week. Okay? Your clients need to understand that when you tell them they're out of a case, because it isn't really true unless that order somehow becomes final. All right. We're getting close to the end of our pre-Q&A time, so we're going to go through a couple of concepts and then skip the rest of it, I think. Some particularly unique aspects of this 250502B1 as they play out in a criminal case. We have criminal defense attorneys here or prosecutors? Anyone? Yeah? Okay. Well, then you probably know this already. But in 2008, in a case called State versus Baker, the Supreme Court laid out the 4 elements that Criminal Rule 32 requires you to have in order for a judgment in a criminal case to be final. The guilty plea, jury verdict, or finding of the court upon which the conviction is based, the sentence, the judge's signature, and a timestamp showing journalization. Simple enough, except that it turned out hundreds and hundreds of criminal defendants who thought they were convicted and who thought that they had final judgments going back years and years and years did not have number 1. They did not have the finding of the court upon which the conviction is based in their judgment entry. And all of these need to be in the same judgment entry in order for it to be final. What does that mean? It means their convictions were never final. And when they appealed from what they thought were final convictions, it means that the Court of Appeals that looked at that appeal had no jurisdiction. So guess what? Hundreds and hundreds of convicted criminal defendants, some of them completed their prison terms, some of them still in prison. Guess what they did? They got the trial court to fix the order, to create the final judgment, and they appealed all over again. And it threw the Ohio appellate process into chaos. Some courts said, no, we didn't have jurisdiction the first time, but, oh yeah, res judicata. Now, how you can apply res judicata to an appeal over which the Court of Appeals didn't have jurisdiction to begin with is beyond me. And that wasn't the only issue, by the way. Other defects here, for example, something defective in the sentence also created these multiple reattempts to appeal. The 6th Appellate District said, no way, it's not that easy. We have to redo every single one of these appeals if they ask us to. So that became a nightmare. So last year, in a case called State versus Lester, the Supreme Court did 2 things. First, it threw out or clarified this first element and basically said the fact of the conviction was all you needed to put into the journal entry. You didn't need all that other gobbledygook, which then clarified that many of the orders that had been thought not to be final actually were final. So we got rid of that part of the problem. And the Supreme Court essentially adopted the res judicata test that some of the courts of appeals had adopted in order to avoid having these redo appeals. I am going to really quickly skip to something important that you should know, that because we don't have time for many of these things, but I wanted to talk very quickly about 2505-02B4. And this is the prong of the statute called the provisional remedy prong. This prong of the statute was added in 1998, and it is one of the most powerful prongs of the statute if you are trying to get the Court of Appeals to look at something in the middle of a case, something that in the federal system we characterize as an interlocutory order. And remember when I explained the bell rule, the one that says that you can't unring the bell, and I used the example of the employee who went to work for a competitor and you got a preliminary injunction forcing that employee not to compete. If you think about that example that I gave you, it would not qualify as a final order under 2505-02B1. It doesn't resolve the entire action or even a separate and distinct branch thereof. It can't be 54B'd unless you resolve a discrete claim, and a preliminary injunction does not resolve a discrete claim. A preliminary injunction simply says, we think you're going to win on this claim, so we'll order the relief immediately, and then we'll have a trial later to figure out whether we got it right or we got it wrong. So you cannot appeal, for example, a preliminary injunction under 2505-02B1. You can, however, now appeal it under 2505-02B4. Because a preliminary injunction is a provisional remedy. A provisional remedy is defined as something ancillary to the action, separate and distinct from the action, and it is specifically defined to include preliminary injunctions, discovery of privileged matter, various other categories of orders, some of them involving discovery, some of them involving collateral items, have been characterized as provisional remedies and can be appealed if they determine the action with respect to the provisional remedy, and more importantly, if the appealing party would be deprived of a meaningful or effective remedy by a delayed appeal, and that, again, is the Bell test. I'm sorry to have to cut off the rest of the presentation, but we have reached almost the end of our hour, and I wanted to leave some time for Q&A. I'm happy to talk more if you want me to, but we have people with microphones here who are happy to come around and take your questions. Please wait for the microphone so that the folks, whoever you are, watching back home can hear the question. Anybody have any? No questions? Well, I can talk more. Why don't you let me know if you have a question, and I'll interrupt, and they can come around at that point. And in the meantime, I can go over a couple of other things. At the beginning of the Ohio piece of this, I showed you a long list of statutes that included the definition, that included orders that were defined by statute to be final. And I told you, focus in the first instance on 2505-02, okay? If we look at that list, there's all kinds of orders that say different things. Sometimes they actually say that something is a final order. For example, 2744-11, I think it is, or 03, says that an order denying qualified immunity to a governmental employee or a municipality or a political subdivision, that is a final order in Ohio. In the federal system, we talked about the collateral order rule. In Ohio, that kind of order by statute is defined as a final order. Likewise, in Ohio, an order that grants or denies a motion to stay litigation pending arbitration is defined by statute to be a final order. Neither of those two categories I just mentioned are listed in 2505-02. Instead, they're listed in different statutes. So you have to know all of them. If you buy my book, they're all listed there. However, there's always a however, and as my father-in-law used to say, always listen to the part of the sentence that comes after the however. It's the most important part. Many of those statutes that purport to tell you that you may appeal something before the end of the litigation do not use the words final order. They say you may appeal X. But if it doesn't actually say X is a final order, then there is an open question about whether, in fact, you can appeal X without separately meeting the definition of final order in 2505-02. So, for example, in 1989, the Supreme Court held that Revised Code 2711-15, which purports to authorize appeals from orders that confirm or vacate arbitration awards, the Supreme Court said that you still have to satisfy 2505-02 in order to appeal from that order, even though the statute 2711-15 suggested that you could by virtue of that statute alone. In the criminal context, there is conflicting authority. 2945-67A is the statute that gives the state the right to appeal from certain kinds of orders in criminal cases. Now, you know that because of our double jeopardy clause, the state's right to appeal in criminal cases is very, very limited, but 2945-67 at least gives you some guidelines as to when the state may appeal. But the courts in Ohio have not yet concluded unanimously whether or not you have to prove that the order is final under 2505-02 in addition to meeting the criteria of 2945-67. Some courts from the 9th and the 7th District say, nope, if it meets the test under 2945-67, go right to the straight court of the Court of Appeals. No finality analysis required. Other courts, also including the 9th District and also the 1st District, say, nope, you do have to, I got it backwards, I'm sorry. The 9th and the 7th say you do need the 2505-02 analysis. The 9th, in a conflicting opinion within the district, said, no, you do need it, you don't need it, you do need it, you don't need it. They can't make up their mind. But the 1st District has said that you don't need it. So we have a conflict there, and conflicts tend to make their way to the Ohio Supreme Court, so this issue possibly will. I told you to drink a lot of coffee. Finally, what happens in the trial court while an appeal is pending?
The issues that are concerning that appeal are stayed.
Exactly right. The issues that are on appeal can't go forward in the trial court. Nothing can go forward on the trial court while an appeal is pending if the jurisdiction of the two courts would conflict. However, the trial court retains all jurisdiction not inconsistent with the Court of Appeals. So if you've got something up on appeal and the trial court wants to do something else that's not inconsistent with the thing that's up on appeal, the trial court can do so. A classic example, if you have a judgment and the judgment is on appeal, that judgment is not stayed unless the trial court stays it or the Court of Appeals stays it. So absent a stay, the trial court may do everything in its power under normal circumstances to help you execute on that judgment, even while the judgment itself is on appeal. Be careful about that, because if a judgment becomes satisfied while the appeal is pending, then the appeal becomes moot and will be dismissed. So always get a stay of the trial court judgment. So in illustration of this, in the Yee case in 1990, the Supreme Court basically said the trial court had jurisdiction because what it sought to do in that case had nothing to do with the issue that was before the Court of Appeals. Interestingly, though, even if you attempt to appeal from something that is determined not to be a final order, so for example, if somebody misuses Rule 54B and makes crumbs out of the Kit Kat bar, and you appeal from that order thinking that it's final because the trial court said it was, the Court of Appeals is not bound by that. The Court of Appeals will dismiss that case once the problem comes to light. So you don't have jurisdiction in the trial court because you filed an appeal. The appeal, however, is improper and will eventually be dismissed. What happens in that interim? And the answer is nothing. In 2011, just last year, the Supreme Court said that a trial court cannot take action inconsistent with the Court of Appeals jurisdiction, even if the Court of Appeals really doesn't have jurisdiction because the order on appeal isn't final to begin with. So there's a lot of room for gamesmanship here, but essentially, if you appeal improperly, you're essentially stripping the trial court of jurisdiction, even though you really don't have appellate jurisdiction. That's about all the time that I have. Thank you for your patience. I'm still happy to take questions if anybody has any, and I hope you now feel the love of appellate jurisdiction the way I do. Thanks for your patience with the technical difficulties.